Hello, my name is Paul Jordan. I'm a partner in the brands team here at Bristows, and I would like to welcome you all to our review of the year. Over the next 45 minutes or so, we're going to highlight 5 of the key cases that are contained within the wider publication. But before we get started, I'd like to introduce you to 2 of my partners, Jeremy Bloom and Simon Clark, who in turn will reflect on some of the key topics and cases over the last 12 months, and very briefly then look forward to issues to consider and look out for over the next year. So without further ado, Jeremy, if you wouldn't mind sharing some of your thoughts when you reflect on the last 12 months.
Thanks, Paul. There were a wide range of cases once again this year in the design copyright space, and it's hard to identify any particular trends emerging. But I can say the Court of Justice added to its vast array of case law relating to the communication to the public right in the VG Builder case, considering the question of framing. Previously, it was considering the question of linking, and now we have an answer in relation to framing, and more will be said in our webinar. The English courts continue to hear multiple blocking injunction cases, and the UK is really at the vanguard of blocking injunctions against ISPs, which then prevent UK internet users from accessing certain information online. The court this year issued its first order against a movie hosting CyberLocker, and that continues its strong traditions of continuing to evolve the scope of a blocking injunction. The highest profile copyright case this year was, of course, the Duchess of Sussex, Meghan Markle. She brought proceedings against the Daily Mail for a privacy and copyright infringement claim. The court found that the Daily Mail had infringed by publishing personal letters, and that there was no fair dealing defence available to the Daily Mail because it was not actually reporting about events. Finally, in the last year, there were numerous database right cases, and that seems to be an increasing trend given the ever-increasing value of databases to the global economy. So there's lots of interesting cases that we cover in our publication and our webinar. Thank you.
Thank you very much, Jeremy. And Simon, looking forward, what are some of the issues and topics that we should all keep an eye on for the coming year?
Yeah, well, picking up from where Jeremy left off, I think databases is going to be one of the key areas in the next 12 months. The UK has said that it wants to be one of the best places in the world for artificial intelligence. And we've still got quite a lot of working out to do in terms of the overlap between copyright and database right, and the extent to which people can develop AI by using other people's data without infringing the database right. And the European cases have suggested that there's going to be a shift away from strong database rights protection to allow people to create artificial intelligence. On the copyright side, I think we will continue to see more debate between our closed list of copyright works under the UK Act and the EU approach after the Cofimel case in terms of not having a closed list at all. And at the moment, we're seeing court pleadings arguing both the UK position and the EU position. So the UK courts will no doubt have to sort that out in the next year or so. And finally, on designs, again, there's a UK consultation out at the moment to try and work out whether we can come up with a single unregistered UK design right, having been left post-Brexit with 2 separate and very different unregistered UK design rights.
Thank you very much, Simon, and thanks again, Jeremy. We're now going to get started and get into our cases, starting with Senior Associate Andrew Butcher. Over to you, Andrew.
Hello, so I'm going to be talking about the CJEU judgment in the case of CV Online and Mellons. It's a judgment from June last year, and it's all about database right under the Database Directive. And I was struggling a little bit to come up with some exciting pictures to illustrate this case, but what I've gone for on the first slide there, those are meta tags. So for those of you who don't know, meta tags are text data which sit behind the visible interface of a website. And they, among other things, they make the website visible to search engines, And depending on the information that you have in the meta tags in your website, they might help your website appear higher up in the search results of search engines like Google. So websites will do quite a lot with their meta tags to for the purposes of search engine optimization, to make them appear higher up in search engine results. And meta tags were a very important thing in this case about database right. So before I get into the factual background, just a little bit of the legal context. So in terms of the scope of database right under the Database Directive, that's set out in Article 7, which essentially says that database right is a right for the maker of a database to prevent extraction and or reutilization of the whole or a substantial part of the database. And extraction essentially means the transfer of the whole or a substantial part of the database to another medium by any means or any form. And reutilization essentially means making the database available to the public. So why should we care about database rights and the Database Directive in the UK at this point, post-Brexit? Well, after the end of the Brexit transition period, the implementing legislation for Database Directive in the UK was amended so that post-Brexit we now have a UK-only version of database rights, and that provides the same rights in the UK as EU database right provides in the EEA. So although judgments from the CJEU are clearly no longer binding on us, they might still inform the approach that the UK courts take. And it's also, of course, useful to know the approach that's being taken in the EU. So onto the factual background then. So on the left is the homepage of the claimant, CV Online, and that is a Latvian jobs directory. So it's basically a big database of job vacancies. And on the right is the website of the defendant. So the defendant, which was called Melons, operated a website called Kur-Darbs, which I think means where to work in Latvia. So the CV Online website included meta tags, as I was discussing earlier. And for each job advertisement in the CV Online database, there was a meta tag, including the keywords job title, name of employer, place of employment, and other keywords like that. And Kur-Darbs on the right-hand side, that's a meta search engine. So that essentially searches other search engines, also known as a content aggregator. So in the travel sector, TripAdvisor would be an example of a content aggregator. So you can do a search on TripAdvisor and then it'll show you possible holiday options from Booking.com, Trivago, and others. So Kur-Darbs, the way that it was using data from the CV Online database was that it was actually displaying the meta tags from CV Online, and it copied meta tags and other content from the CV Online database onto its own server, indexed it, and then allowed its users to search CV Online and other job databases in one single place. So CV Online wasn't happy about what Melons was doing, and so they sued for infringement of database right, saying that Melons was extracting and reutilizing a substantial part of their database. The Court of First Instance in Latvia found infringement on the basis of reutilization, so essentially making the database available to the public. Melons appealed to the regional court in Riga, and the regional court decided that it needed to refer a couple of questions to the CJEU. So the first of those was whether using a hyperlink to redirect end users to the website of a database owner falls within the definition of reutilization in Article 7 of the Database Directive. And the reason that was relevant was because on the Kur-Darbs website, once you'd performed a search, if a job on CV Online was of interest and corresponded with your search criteria, you would then get a hyperlink to take you through to the CV Online database. So that was the first question. The second question was whether Melons' use of CV Online's meta tags falls in the definition of extraction in the Database Directive. So as usual, the CJEU decided that it needed to reformulate the questions referred by the regional court. Before it reformulated those questions, though, CJEU made clear that in the CJEU's view, the referred questions were based on the premise that CV Online's database satisfied the requirement of substantial investment in obtaining / verification, presentation of the contents of the database, because if you haven't got over that threshold, then your database isn't protected by database right in the first place. So on that basis, the CJEU said that it was for the referring court to decide whether the substantial investment had been met, and also whether CV Online's meta tags constituted a substantial part of the database. So the CJEU did not consider those 2 points within its judgment. So in terms of how the CJEU decided to reformulate the questions that were referred to it, the questions weren't changed massively. Arguably, they're slightly broader than the questions referred, and the answers will have slightly wider application. So it makes some sense that they've reformulated the questions slightly. Essentially, there's in the reformulated questions, there's no reference to hyperlinks specifically in the context of reutilization, and there's no reference to meta tags in the context of extraction. So the questions on screen are the ones that the CJEU decided to answer. So on to the decision. So the first thing the CJEU did was decide whether or not the definitions of extraction and reutilization under the Database Directive had been satisfied. And the CJEU found those questions very easy to answer. They answered them very quickly. On extraction, they said that yes, by indexing and copying the content of CV Online on its own server, Mellons was transferring the content of the database to another medium. And on reutilization, they said Mellons was providing the public with access to the entire content of the CV Online database by means other than that provided by CV Online. So yes, there was extraction. Yes, there was reutilization. However, the CJEU said that before they could decide that there was infringement of database right, there was another criterion which had to be satisfied. So in order to establish that additional criterion to be satisfied for infringement of database right, the CJEU considered the scope and purpose of database right. And to do that, they looked at the recitals of the directive, and they looked at previous judgments of the court in British Horse Racing Board, and also the case of InnoWeb, which was particularly relevant because InnoWeb was another meta search engine, just like the Kurdarbs search engine in this case. So in terms of the scope and purpose of database right, CJEU said it protects the substantial investment in obtaining, verification, presentation of the contents of the database for the limited duration of database right. It also ensures that the database maker can redeem the cost of his or her investment by protecting him or her against unauthorized appropriation of the database, i.e. acts which go beyond the legitimate rights of a user. And when they're talking about redeeming the cost, they're talking about things like in the case of CV Online. CV Online has lots of advertising on its website. And so the more eyeballs it gets on its website, people looking for jobs, the more it can charge for advertising inventory on its site. And the third key point on the scope and purpose of database right, the CJEU said that it's for the stimulation of the establishment of data storage and processing systems which contribute to development of an information market. So essentially, the CJEU wants there to be a market for buying and selling information products, essentially. So, as always, the CJEU decided that there was a fair balance to be struck here between two opposing sets of legitimate interests. And they made clear in their judgment that content aggregators, such as Kurdarbs in this case, do have benefits. So they are part of the development of the information market that we were talking about just now. They provide improved structure to online information and allow more efficient searching. And they also contribute to the smooth functioning of competition and transparency of offers and prices. So there are major benefits for consumers there. So the CJEU said there's a balance to be struck between the legitimate interests of database makers in redeeming their investment on the one hand, and users and competitors in having access to information, potentially creating innovative products based on that information. And innovative products include meta search engines, which are very useful to consumers and to competition in general. So after striking that fair balance, the CJEU, their decision in this case was that the judgment they came to was that Article 7 of the Database Directive must be interpreted as meaning that a meta search engine which copies and indexes the whole or a substantial part of a database freely accessed on the internet and then allows its users to search that database on its website is extracting and reutilizing that content within the meaning of the database directive, where those acts adversely affect the investment of the database maker in obtaining, verifying, or presenting the content, and in particular, they constitute a risk to the possibility of redeeming the database maker's investment through the normal operation of the database in question. And it's for the referring court to decide whether or not there is that risk. So finally, in terms of the implications of the judgment here, I think it's useful clarification of the scope of database rights. It's important to mention that this additional requirement about the extraction or reutilization having to constitute a risk to the possibility of redeeming the investment of the database maker, that's not in Article 7 of the directive itself, although paragraph 5 of Article 7 does hint at it, because paragraph 5 refers to acts which conflict with the normal exploitation of a database and acts which unreasonably prejudice the legitimate interest of the database maker. And paragraph 5 makes clear that those sorts of acts won't be permitted. So it remains to be seen whether the UK courts will follow the approach of the CJEU here and say that there is this additional criterion of there being a risk to the possibility of redeeming the database maker's investment. And I think it would be very sensible for the UK courts to follow this approach, because ultimately it protects the operation of conventional search engines such as Google and Bing, because unlike in the case of Kurdarbs, search engines such as Google and Bing, they won't prevent users going to the CV Online database and actually visiting that website and seeing the advertising on that website and allowing CV Online to redeem their investment in the database that way. With Google and Bing and other conventional search engines, when you do a search for jobs in Latvia in IT or something, Google will present you with a search result which indicates that you need to go and click through to the CV Online database and actually have your eyeballs on their website. Whereas in the case of Kurdarbs, they were providing this one-stop shop, which was allowing you to search the content of CV Online and a whole lot of other databases without visiting their website. And therefore, if you didn't find anything of interest on any of those websites, the user was being able to avoid the need to actually visit those websites and obviously increase the website's views, and which in turn allows the website to charge more for advertising or redeem its investment that way. So I think it makes sense to essentially protect the function of normal search engines in this way, to protect them from infringement of database right, because ultimately websites like CV Online do rely on and benefit from conventional search engines in that way, and it's only meta search engines like Kurdarbs which operate in this very specific way, which is potentially damaging to the investment of the database maker. That's all I have to say on this case. Thank you very much for listening.
Thank you. I would now like to introduce you to Senior Associate Toby Hedden.
Hello, I'm Toby Hedden, and today I'm going to be talking about a case involving the communication to the public right. So I'll start off with a little introduction. In this particular case, the Court of Justice revisited the communication to the public right in the context of framing. Now, in simple terms, framing is a type of linking where a web page includes a frame, and in that frame is content from another website, and that's shown inside the frame. Sometimes a web user has to click on a hyperlink to make that content appear in the frame, and sometimes it loads automatically, particularly if an embedded link is used. So a little bit about the background. Linking and the communication to the public right have had a really good airing in the Court of Justice over recent years, and it's probably helpful to mention here just a few of the key decisions to set some context for this discussion. The first case I want to start with is the seminal decision of Svensson, which the Court of Justice decided that posting a hyperlink to a freely available and copyright protected content is not an infringement of the communication to the public right in the absence of any communication to what is called a new public, and that's essentially a section of the public not taken into account by the right holder when they originally authorized the initial communication that made their work available. The second case is the TV catch-up case. Now here, the Court of Justice found that where a communication to the public is made using a different technical means to those used for the initial communication, the new public requirement may not be necessary. Now, if you think about this in the context of linking on the internet, it's pretty difficult to see how the technical means would be different if the initial communication was also made via the internet. And the last case that I want to touch on is GS Media. And in this case, the Court of Justice considered hyperlinks to freely available content which had been made available but without the authorization of the copyright holder. And it decided that Svensson could only have been considering hyperlinks to freely available works that had already been made and authorized by the copyright holder, so did not exclude the possibility of works which hadn't been made with authorization from being an actionable communication to the public. But that was assuming that the user in question had knowledge of that fact. So just considering that backdrop, one point that hadn't been addressed until the case I'm about to discuss, VG Build, that hadn't been tested before the Court of Justice was the extent to which website terms of use could actually be relied upon to effectively withhold authorization and therefore restrict linking to copyright protected content. I'll talk a little bit about the facts and then we'll get on to the meat and potatoes of the case. So the parties, VG Build itself was or is a copyright collecting society, and its opponent SPK operates a digital library called the DDB, which it makes available to others online. The dispute itself that underlied the reference concerned a provision in a license agreement between SPK and VG concerning SPK's use of VG's catalogue of copyright works through its DDB website. And what VG wanted to do was to impose a contractual obligation on SPK to implement technological measures to prevent third parties from framing VG's works, bearing in mind that these works would be freely available on the DDB website. And SPK objected to this provision. So in the proceedings in Germany, the court had to decide whether the framing itself would be a communication to the public if it involved circumventing the technological measures that VG wanted to impose on SPK. If it did, then VG would be entitled to require those protection measures. So with that in mind, the German court referred a question to the Court of Justice, which I've included on the slide, and it's essentially whether the embedding of a work which is freely available and accessible on a website, having been made so with the consent of the right holder, in the website of a third party by way of framing constitutes a communication to the public of that work within the meaning of Article 3 of the Information Society Directive, where it circumvents protection measures against framing adopted or imposed by the right holder. So what did the Court of Justice decide? So they decided that framing was capable of constituting a separate act of communication to the public, but the technical means used for this separate act of communication to the public, i.e. the internet, would be no different to those used by VG Build when it initially made its catalogue of works available. So because of this, VG Build would need to show that the communication was to a new public if it was going to be an actionable communication to the public. The Court of Justice decided the point in favour of VG Build on the basis that they could not be regarded as having consented to the communication to the public of their catalogue by SPK through framing, even though that catalogue would otherwise be freely available. So in that sense, the Court of Justice appears to have sort of answered the outstanding question on the extent to which website terms of use can be relied upon to withhold authorization and restrict linking to copyright content. I say sort of here because the scope for doing that appears to be quite limited. The CJEU expressed the view that imposing technological measures was the only way in which a copyright owner, such as VG Build, could limit their consent. So it seems that the copyright holder can only limit the scope of their consent to someone else communicating their copyright works to the public through website T's and C's, where the provision itself requires the other party to impose a technological protection measure. I think in terms of framing, at least the user is not required manually to check the terms of use for each and every website that they propose to utilize to see if there is any restrictions. That's a consequence of this decision. And in that sense, it's a very pragmatic decision because obviously checking terms of use for each website is quite a serious undertaking and it would take up a lot of time. Perhaps the final point to bear in mind about this case, though, is that although it concerns framing, it could present something of a challenge for anyone who wants to prevent use of their website content by including restrictions in their terms of use. And these sorts of restrictions are very common. I mean, we see terms of use which have restrictions such as, you can't use this for commercial purposes. And I think this is really because the Court of Justice suggested that the technical measures was the only way of withholding consent. I think that's the key point for me in this case, and it's a very interesting one. Thank you very much for listening.
Thank you. I would now like to introduce you to Lucy Fortune.
Hello, my name is Lucy Fortune, and I'm here to talk to you about Original Beauty and G4K. So, Original Beauty and G4K, as things stand, there have been 9 judgments on this case. I'm not proposing to talk about all of them today. I'm going to talk about 3. So the first one is really the main merits judgment. So by way of background, the claimants sell women's clothing under the brands House of CB and Mistress Rocks, very popular online, and their names you may have heard of. And the defendants sell women's clothing under the brand O Polly. So the claimants alleged that the defendants had copied 91 of their designs, and that infringed both UK unregistered design right and community unregistered design right. And you can see there in the picture on the slide, so C35 is one of the claimants' designs, and D35 is one of the defendants' designs, similar designs. You can see they do look very similar. The defendants, there was also an allegation that they had passed off their brand O Polly as a sister brand of House of CB. So at trial, the judge decided in advance that they were only going to consider 20 out of the 91 garments at issue in order to streamline the case, because 91 garments was just going to be too difficult. Now, in the course of evidence, the defendants admitted that some of the claimants' designs, they said, had been referenced but not copied. Now, it came out in the evidence that the defendant's designer, unfortunately, didn't really have any design talent herself. And I will quote from the judge here. The judge said, "It was common ground that Ms. Henderson, who was the designer at the defendants, cannot draw. She also cannot use any of the available computer-assisted design programs. Her evidence was that she designed by looking at trends from images she collected in her Dropbox, designed the details of each garment in her head, then looked for images of existing garments which she could use to show the factory what it was she wanted made. There are no documents which back up this account of her design process." And the judge went on to conclude, "I consider her version of her design process to be a fabrication, concocted to get around the very real difficulty that Ms. Henderson took images of the claimant's garments and sent them to the factory to be made up." So, doesn't look very good, or didn't look very good after the evidence for the defendants. And the judge concluded that out of those 20 designs, 7 had indeed been copied, and that infringed the claimant's UK unregistered design right and community unregistered design right. Now, in relation to the remaining 71 garments, the judge directed that the parties should try to seek to resolve the dispute themselves by consent. And in terms of the passing off claim, the judge found that although there was clearly an intention to pass off O Polly as a sister brand to House of CB, particularly in terms of advertising content, branding, that kind of thing, he found with some reluctance that sufficient members of the public had not been deceived for misrepresentation to be made out, and therefore the passing off claim failed. So then there was an interesting judgment, which is not very common, which was a judgment after the main judgment, which I'm calling the Colorways judgment. And what happened here is that the defendants sought some clarity on some of the judge's findings in relation to how to assess the different colorways of the infringing designs. So the judge clarified in this judgment that in relation to UK unregistered design right, all of his findings there prevented sales of the infringing designs in all colorways. And that's because UK unregistered design right does not protect color or surface decoration. However, the legal test under community unregistered design right is quite different. and some different colorways didn't infringe because they created a different overall impression. So by way of example, and you can see some pictures there on the slide, D2, the design on the left-hand side in the middle, D2 in the color dark rose did infringe the claimant's community unregistered design right in the claimant's design C2 in wine, but the sage colorway didn't infringe community unregistered design right, and that was because the judge found that it produced a different overall impression on the informed user. Similarly, for the C12 and D12 designs, the judge found that the D12 design in sage did infringe the claimant's C12 design in white, but rose didn't infringe, again, because it produced a different overall impression. Now, part of the reason why the judge decided to issue this additional judgment is he said he hoped that the different guidance that he provided would assist the parties in agreeing the disposal of the claims relating to those 71 remaining garments. So the next judgment to consider, which is a really interesting one, is the damages inquiry. Now, damages inquiries are relatively rare in IP cases, and the reason is because normally you have a liability trial and the parties then will come to an agreement, some kind of negotiated settlement over how much damages are to be paid, rather than going through the cost and time incurred with going through a huge damages inquiry, where often there is an enormous amount of evidence that needs to be put forward and gone through. But in this case, like lots of the parts of the proceedings up to this point, the claimants and the defendants could not agree. And therefore, they found themselves back in court for the damages inquiry. So the general principle is to put the claimants in the position they would have been in had the infringement not occurred. And so, as I mentioned, the judge had found in the main judgment that there were 7 infringing designs. So the defendants disclosed that of those 7 infringing designs, they sold 15,393 infringing garments. So the question was how to deal with those. So the claimant's position was, well, they were entitled to damages under 3 heads. They said, firstly, lost profits on their lost sales. Secondly, a reasonable royalty on any of the sales that weren't covered by the first head. And thirdly, additional damages. And they argued, and the court agreed, that they were entitled to additional damages because the defendant's infringement had been really so flagrant. And adding all of those things together, the claimant submitted that they should receive approximately £500,000 in damages. Now, the defendant's position, unsurprisingly, was quite different. They, first of all, denied that lost profits damages were payable at all. They did accept that a reasonable royalty was payable, that they valued it at £1 per infringing garment. And although they also accepted that additional damages were payable, they said that that should be no more than a 20% uplift on the reasonable royalty. So they said that they thought that they owed approximately £18,000. Clearly a huge difference between the two, and you can see why they ended up in court to decide this. So the first thing to say, just as a preliminary point, is make sure if you find yourself in this scenario where you have gone to a damages inquiry as an infringer, an infringement has been found, absolutely make sure that your disclosure of the amounts of your sales and the profits on those sales is accurate. Unfortunately, in this case, it became clear that the defendants, in relation to some of the designs, they hadn't actually ceased selling the infringing products despite saying that they should and having been ordered that they should, or they'd ceased selling and they'd restarted. And that meant that the figures that they'd given were not accurate because they didn't record these additional sales. And also, the judge later found that that meant that the statements of case were inaccurate. The judge didn't take very kindly to this. So that is just a cautionary tale and a warning there. Now, in terms of that first head, lost profits, the judge said he had to consider 2 questions. The first is just generally whether on the balance of probabilities, the claimants have suffered some loss under this head. He was satisfied that that was the case here because the claimants and defendants were direct competitors. The second and more tricky question is, on the basis of the available evidence, how much loss has actually been sustained. And he said the way to calculate that is you look at the lost sales, and then you look at the total number of sales and you times that by P. And there is debate over what P is. So the claimants originally claimed that P should be 1. So that means that for every infringing sale made by the defendants was a sale in effect lost by the claimants. That is very, very difficult to make out. And actually, after the submissions, by the closing submissions, the claimants had changed their position and submitted, okay, P instead was 0.25. What that means is for every 100 infringing sales, 25 of those were sales lost by the claimants. And it's a very difficult decision to come to by the court. It's never going to be something that's going to be easy to be precise about. So the judge said the court just has to form a general view based on all the circumstances. And in this case, the judge held that P equaled 0.2, so awarded the claimants approximately £75,000 in lost profits under this head. The next head was a reasonable royalty. So the claimants claimed around £11 a garment, and the defendants said £1 a garment, again, quite far away. The court said that what they had to do was try to figure out what hypothetical agreement the claimants and the defendants would come to, would have got to. And it was clear in practice that these two were never going to have agreed, but the court's job, they said, was to bridge the gap to work out what that hypothetical deal might have been. So the court said, well, the royalty should be based on a percentage of the defendant's sales at their selling price. They treated partial and whole designs the same. And the court said the defendants had no other potential source of successful on-trend designs. And this was because they had already found in the main action that the defendant had no design capability themselves, nothing in-house, everything was copied or at least referenced from third-party designs. There were no in-house designing happening. So they said, well, on that basis, the defendants would have been prepared to pay above average royalty rates. So they made that calculation, and again, they worked out at about £75,000 in total under this head. The final question was the additional damages due to flagrancy of infringement. So the court considered this and looked at a number of different factors. The first factor was over 15,000 infringing garments. This was not minor infringement. This was serious infringement on a very large scale. And it was very flagrant infringement. It was carried out over a course of 4 years. The defendants also continued to deny copying throughout the liability trial, and the judge had found that the defendants' key witnesses had lied at trial. And the court was clear that they needed to both punish and deter the defendants in a way that was effective, proportionate, and dissuasive. So looking at the figures, they said, well, the defendants made just under £200,000 profit from the infringing designs and had quite a chunky turnover of £4 million. And on that basis, the court decided to award £300,000 in additional damages. And the court said, given the profit made from these infringing garments and the size of the defendant's business, in my judgment, only an award of this size will be sufficient to punish them for what they've done and to deter them from infringing again. No lesser amount would achieve that. This is what the justice of the case requires. Now, this is an interesting case because often it's the case that damages in design right cases are quite small, but here, clearly the figures were very large, and there are a number of different factors as to why that was the case. But this again is another cautionary tale as to what can happen if things go wrong with designs. Thank you very much for your time.
Thank you. I would now like to introduce you to Senior Associate Tim Heaps.
Hi everyone, I'm Tim Heaps and I'm going to be talking to you today about the Court of Appeal case between TuneIn and Warner Music. It's a case which primarily focuses on the communication to the public right in the world of digital music. And it's also interesting from a wider perspective in that it's a decision which was handed down after the end of the Brexit transitional period. So it provides quite a useful indication as to how the UK courts will likely approach Section 20 and possibly the CDPA more widely post-Brexit, at least in the short term. So in terms of agenda, to set the scene, I'll firstly take you through some of the background, including some of the relevant elements of the High Court decision from 2019, then turn to the findings of the Court of Appeal decision in a bit more detail, and then finish off with some general observations and take home practical points. So starting with the defendants, TuneIn is a radio aggregation platform which essentially acts as a one-stop shop, allowing its users to access thousands of online radio streams being broadcast over the internet. And it does this with the use of hyperlinks and indexing. Now, from a presentational perspective, the judge described TuneIn's service as a kind of framing, in that when the user selects a particular radio station, they remain on the TuneIn app or website rather than being redirected to a third-party site. So from the user's perspective, it appears as though all the content is being provided by TuneIn. In addition to that, there are a couple of aspects of the platform which are noteworthy just for the purposes of going through the judgment. And these include the provision of what was quite a sophisticated browsing feature, which allowed TuneIn's users to search for and browse stations and different categories of music. And it also provided a premium service called TuneIn Pro, which allowed users to record radio streams, among other things. So moving on to the claimants, Warner and Sony Music, together with the group of companies that they represent, own or hold exclusive licenses to a pretty huge volume of sound recordings and music, and between them account for well over half the market for digital sales in the UK. So a very, very large market share. And in 2019, they brought a claim of copyright infringement against TuneIn's activities, with the core issue centering around whether hyperlinks to radio stations broadcast in other countries constitute a communication to the public, and therefore an infringement under Section 20 of the CDPA. So I'm not going to go into the High Court case in too much detail, but just to set the scene a little, there are a huge number of radio stations to consider. So the first instance judge divided them into 4 separate categories, which I've listed on this slide. The first being stations which were licensed in the UK, the second being stations which weren't licensed in the UK or anywhere else. Thirdly, stations which were licensed in a territory outside of the UK. And finally, premium stations created exclusively for TuneIn subscribers, which similarly weren't licensed in the UK. And as you can see from the very elaborate artwork I've included on the slide, the judge held that the links to stations in categories 2 to 4 constituted communications to the public, and therefore infringed the claimant's copyright, whereas links to category 1 stations didn't amount to communication to a new public, on the basis that those stations were already freely available to users in the UK. That final bullet, however, the judge did determine that links to all the stations in all 4 categories, so including category 1, were infringed when users utilized the recording function in the premium version of the app. And that was on the basis that it constituted a communication to a new public via a new technical means, and that follows the principle set out in the earlier case of TV catch-up. So following the High Court decision, TuneIn raised a number of grounds of appeal, and in doing so challenged not just the findings of the High Court decision, but also the entire body of EU jurisprudence on the subject in relation to Section 20. So it's fair to say it was quite a bold, scorched earth approach to their appeal. Before coming on to those rather more far-reaching submissions, the court dealt with a couple of discrete arguments first, namely in relation to targeting, and then also the defendant's attempt to compare its service to a standard search engine. So on the targeting point, after the High Court's decision, TuneIn did accept that the platform itself targeted the UK. However, the argument that they made was that the targeting assessment should be made at the level of the individual hyperlink, and that those weren't targeted at the UK. But the Court of Appeal rejected that contention, with the judge concluding that the audience being targeted by the platform was still the most relevant and valid consideration. And then with regard to the search engine comparison, TuneIn, as they had in the High Court decision, argued that its platform was akin to a search engine, and should be viewed in the same way when assessing its liability for copyright infringement. And again, the Court of Appeal sided with the High Court's ruling on that, and confirmed that the TuneIn platform went far beyond a basic search engine's offering, in that even at a purely technical level, it provided framed links to streams incorporating sound recordings. And then finally on this slide, just turning to Section 20 more specifically, one of TuneIn's primary contentions was that the High Court failed to correctly apply EU case law on the subject. And the key issue in this regard was that the hyperlink to radio stations had been whether they'd been communicated to a new public. And this ultimately depended on the scope of authorization by the rights holder to the original audio streams. And on that point, TuneIn argued that the recent post-Brexit case of VG Build was authority for the principle that a rights holder can only limit its consent to linking or framing through the use of effective technological measures. And whilst the court did consider that there was some merit to that argument, it ultimately took the view that the conclusions from the case of VG Build shouldn't be extrapolated beyond the specific facts of that case. And then finally, coming on to the argument which probably had the most far-reaching and significant implications, was TuneIn's contention that the Court of Appeal should use its new post-Brexit powers to depart from an entire body of EU case law in relation to communication to the public. And perhaps unsurprisingly, the judge firmly rejected that invitation, citing a number of reasons, a few of which I've included on the slide. The first being that although it's now free to make amendments, there hasn't been any legislative change by the UK Parliament to Section 20, or indeed the international copyright framework post-Brexit, in a manner which would necessitate a different approach being taken by the courts. Secondly, although the EU probably isn't entirely free from criticism in terms of its various judgments, it was acknowledged by the Court of Appeal that it's a notoriously complex and thorny area of the law, with solutions not really being readily available. So given the CJEU's experience, it was felt that they remain best placed to deal with the difficulties of interpreting Section 20. And then finally, the very valid point was made that departing wholesale from the principles established by the CJEU would create a considerable degree of legal uncertainty both now and going forward. So turning to the conclusions from the judgment, despite the rather fatalistic claims of the respective parties that the outcome of the case could, on the one hand, either fatally undermine copyright or indeed at the other end of the scale, break the internet, the feeling is that the status quo does remain, at least insofar as the UK's approach to Section 20 in the context of hyperlinking and framing. It was and is, however, accepted that there does remain a degree of tension between EU case law on the subject. So it does seem inevitable that the law at EU level will continue to develop as it continues to grapple with those various issues. But whether the UK courts continue to follow those principles going forward does remain to be seen. So that's it from me today, and thank you very much for your time.
Thank you. I would now like to introduce you to Senior Associate Sean Ibbotson.
Hi everyone, my name is Sean Ibbotson, and today I'm going to cover the joint cases of Peterson and Google and Elsevier and Ciando, which reached the CJEU in June of last year. This is a really interesting decision, primarily about the communication to the public right in copyright law, and one which is particularly relevant for online platforms. So, as I said, these are joined cases, and it's worth just looking at the background to the disputes and the facts behind them so that we can understand the reference which was made and the questions which were asked of the General Court of the CJEU. So the first of the factual disputes, both of these took place in Germany, one in Hamburg and one in Munich. In the first dispute, the claimant was a gentleman called Frank Peterson, who produces audio recordings. One of these recordings that he produced was Sarah Brightman's Winter Symphony. He became aware that a user, a third party, had uploaded some of these audio recordings to YouTube, which is a video sharing platform, which I'm sure you're familiar with. In the second dispute, similar fact pattern. Elsevier is a publisher. It specializes in medical textbooks. Apparently Grey's Anatomy for Students is one of its textbooks. Similarly, a user had uploaded that textbook to the Uploaded file hosting and sharing platform, which is operated by a company called Ciando. So these gave rise to two separate proceedings in Hamburg and in Munich. And the key issue in each of the proceedings were whether or not the platform, so Google and Uploaded, are responsible for the copyright infringement which has occurred as a result of the user uploading content to the platform. So there were three questions which were referred to the CJEU. I've greyed out two of them because we haven't got time to cover the second and third in too much detail today, but we will just touch on them very briefly. The main question is the one highlighted blue, which is about the communication to the public right. And fundamentally, the question asked of the CJEU was, do the operators of the video and file sharing platforms make a communication to the public within the meaning of Article 3 of the Copyright Directive? Now, just to briefly touch on the second and third questions, the second question was about the hosting exemption, which is provided by Article 14 of the E-Commerce Directive. And the question was, what circumstances lead a platform to firstly fall within the scope of that provision, and then also exclude that platform from the safe harbour which it provides. And the third question is to do with injunctions against intermediaries. So let's have a look first of all at the first question and what the court said. So the CJEU said that an online platform such as YouTube or Uploaded makes a communication to the public if it firstly plays an indispensable role, and secondly makes an intervention which is deliberate in nature. In both cases, the court was quick to say that both YouTube and Uploaded had played an indispensable role in the content reaching a new public So that part of the judgment wasn't really that controversial. The second bit is more interesting, and the question of whether or not the platform has made an intervention which is deliberate in nature. Now, fortunately, that rather Delphic and circular comment is backed up by what the court has provided in the way of a list of factors which indicate whether or not a platform has or hasn't made an intervention which is deliberate. Now, it's very clear that the court is very clear that this is a non-exhaustive list, but it's quite comprehensive and it's very useful. So what the court said here is that the factors which might suggest that a platform such as YouTube or Uploaded has made a deliberate intervention include the following. So the first is that it's got specific knowledge of infringing content, but it refrains from expeditiously removing it. The second is that it knows, or it ought to know in a general sense, that users upload infringing content, but then the platform refrains from putting in place any technological measures that should be expected basically from a reasonably diligent operator. The third is that the platform participates in selecting infringing content. The fourth is that the platform provides tools which are specifically intended for sharing infringing content. And the fifth is an interesting one. It's that the platform knowingly promotes such sharing of infringing content, for example, by adopting a business model that encourages users to share infringing content. Now, rather unusually for the Court of Justice, whilst it recognised that it was for the national courts to apply these findings to the facts of the case, the court then went on to have a go at doing that job itself, basically, and to reach some findings based on the facts which it had been provided about both YouTube and Uploaded. And so we see how the Court of Justice thinks that its findings are likely to play out in the national proceedings. And it's important at this point that we then separate the two cases out and to look at Uploaded and YouTube separately. So turning to YouTube first, the Court of Justice said that YouTube doesn't intervene in the creation or selection of uploaded content, and it doesn't monitor content before it's uploaded. It also found that YouTube clearly informs users that uploading infringing content is not permitted, for example, in its terms of service. And then thirdly, the court was also said that YouTube has put in place various technical measures which prevent copyright infringement, including content recognition software, which alerts right holders to potential infringements. And all of these factors suggest that YouTube does not engage in a communication to the public. For Uploaded, well, the position is a little less clear-cut, and primarily this was because there are still some key facts which were in dispute in the German proceedings. But the CJEU said that, well, if, as it's alleged, infringing content makes up a very high proportion of files on Uploaded, perhaps over 90%, and if Uploaded has failed to implement appropriate technological measures for countering that infringing content, and if Uploaded's business model is based on the availability of infringing content, then all of these factors will indicate that Uploaded has made a communication to the public within Article 3.1. So it's clear from this part of the judgment that the two platforms take very different routes and will potentially end up in different places in the national proceedings. I promised that we'd very quickly look at the remaining questions which were asked of the CJEU. The second question was about Article 14 of the e-commerce directive, which is the hosting exemption, which many of you will be familiar with. And the court didn't spend much time on this question, but it said that a platform will fall within Article 14, provided that it does not play an active role of a kind such as to give it knowledge of or control over the content which is uploaded to its platform, and that the exemption provided by Article 14 will be lost if the platform has knowledge of or awareness of specific illegal acts. On the third question, this was really a question about German law, but it is quite interesting and more widely applicable. So Article 8.3 of the Copyright Directive provides that member states must enable claimants to obtain injunctions against intermediaries. And German law reflects this, but does state that the intermediary must be first notified of the infringement and then also fail to act expeditiously. And the CJEU was asked whether this was compatible with Article 8.3. And the CJEU essentially said yes, that was compatible with Article 8.3, provided that this does not result in a delay which causes disproportionate harm to the rights holder. This is largely a favourable outcome for platforms such as YouTube, with well-established measures to counter infringement. But you might be sat there thinking, so what? Doesn't Article 17 of the Digital Copyright Directive establish a whole new regime for online platforms? Well, that's right, it does. But there's a few reasons, I think, why this judgment remains relevant. The first is that not all platforms will be caught by the definition of online content sharing providers, which will therefore be caught by the Article 17 regime. So other online platforms will still be governed by the old rules, basically, which is what was in dispute in this judgment. The second reason is that despite the deadline having passed to implement Article 17, and the Digital Copyright Directive more generally, lots and lots of EU member states have not yet done so. The latest figures, I think, are that 3 member states met the deadline for implementing the directive. A couple of others have followed since, including Lithuania very, very recently, but it's still not been implemented widely across the EU. And then the third reason, from a UK perspective, why this judgment remains particularly relevant is that, as you might be aware, the UK has decided not to implement the Digital Copyright Directive at all, and will instead be presumably either following the old rules, which remain part of UK law following Brexit, or it will go its own way. So for those reasons, this Cyendo and YouTube judgment remains really relevant and a particularly useful finding, especially for parties such as Google. Thank you very much. That's all on this case.
Thank you all very much for joining us on this webinar. I hope you found it useful and engaging. It goes without saying, if you have any questions at all, please do not hesitate to reach out to any of us here at the Bristows team. Many thanks.